What happens if my tenant doesn't pay rent? Welcome back inside Uplift Property Management. I'm Marley Davis. I'm the Director of Operations here at Uplift, and I'm going to quickly go over our eviction process today, from delinquency all the way through to a sheriff lockout. So to start, I wanted to quickly go over what we call our delinquency process, or our delinquency timeline. That starts on the 26th of the month when our property management system sends out an automatic rent reminder to all of our tenants. This, of course, is a preventative measure to try and avoid as many late payments as possible. But then, of course, we give our tenants a 3-day grace period to make those rent payments. So from the 1st to the 3rd, we're waiting, following up, sending another automatic rent reminder to try and get that rent in on time before the grace period is over. However, on the 4th, or the first business day following the 4th, we begin our delinquency outreach process and we prepare 3-day notices. This, of course, involves members of our team calling, texting, emailing, and then driving down to your property and attempting personal service of a 3-day notice to pay rent or quit. And again, we try to make this all happen on the 4th. Sometimes that's not until the 5th if the 4th was over the weekend, but we get this done as quickly as possible following that grace period. Now, between the 4th and the 8th is when we're going to do continued delinquency reach out. We're going to call them, we're going to text them, we're going to email them, and at this point they've been served a 3-day notice and we are waiting for that 3-day notice to expire before we start what we call our eviction avoidance process. Now, when it comes to evictions, we like to talk about a tenant breaching the contract, that contract being the lease. Of course, that can be two different things. It could be for a non-payment of rent or what we like to call a significant material breach. Today, I'm going to focus mostly on that non-payment of rent, primarily because the significant material of breach is way harder to prove and it allows them the opportunity to cure. So it is much harder to do a full unlawful detainer and eviction for a breach of the lease. So today we're going to talk about the non-payment of rent situation. And here you can see that we said this does not usually include those other charges like a late fee, a utility fee, or any other fees that are going on at your property. Now, do we waive those and forget about them? Absolutely not. But when it comes to an eviction, we are focused primarily on the non-payment of rent because that's what we've been able to actually get possession back of a property for. The other things, we have been unsuccessful in our time, mostly because the California court system does not care about those things as much as they do payment of rent. So that's your strongest case when it comes to taking back possession of your rental property. So the next thing that we do, I talked about this in our delinquency process, right? We're serving that 3-day notice. And this 3-day notice is for payment of rent or quit. What does or quit means? That means to return possession back of the property. So they have 3 business days from the date that that is served. So if I serve that on a Monday, they have Tuesday, Wednesday, Thursday to either make payment towards that outstanding rent balance or to quit, return possession of the property. So once we've served this notice, we are tracking it within our system to keep track of those 3 days and more importantly, to keep track of when that 3-day notice expires. Now, your 3-day notice has expired. What do we do next? It is time to negotiate. I'm going to cover at the end of this conversation the cost of going straight to an eviction versus trying to do an eviction avoidance negotiation and the benefit that there is to both of those options. But very quickly, that negotiation process is essentially our team, primarily either me or our CEO or broker, applying pressure and providing options. Possession is the most important thing here. At this point, we're already towards the 8th of the month at the earliest. Sometimes it's closer to the 10th or the 12th, depending on business days and weekends. And so we want to get possession back of the property. We're less concerned about paying off the rent balance, although sometimes it's worth it if they're willing to pay it in full in certified funds that day. But our primary focus is to get possession of the property, which is why we are providing options. Now, these are just options. I would have a conversation with you, the owner, if you were one of our clients regarding what option you're comfortable with and what option we recommend for your property. But those options can include forgiving part or all of the delinquent balance. It can include returning the full security deposit, but that is all dependent on possession. So this is a conversation we have with the tenants that if X, then Y. right? We want to make sure that there is some incentive for them to return possession because it's in our best interest and in the tenant's best interest to avoid any sort of legal action. Now, I hate that word failed negotiations, but unfortunately that is what it looks like sometimes. Sometimes we're unable to get a hold of the tenant or they're unwilling to work with us, and that's when it is now time to send it to an attorney. We have a legal team that we have partnered with that we work on all of our eviction cases. They've been extremely successful and we enjoy working with their team because of how responsive and how experienced they are with these sort of issues. So when we send it over to the attorney, we want to make sure that we include all documentation. We want all of the leases, all of the notices, that entire tenant rent ledger, including other payments or charges that are due to them. We send it all to our legal team for them to review and to go through it with us to make sure that we can prepare the documentation that we need to be successful. We don't want to file an unlawful detainer if we were not going to be successful in that because we haven't checked and verified all the documentation. So I send over the documentation to our attorney, and then unfortunately this is where it can get expensive, right? Beyond just the expense of rent not coming in, there is a cost to working with a legal team. We've put in here, it generally comes out to about $2,500. That can include reviewing all of the documentation and preparing the file. But of course, this is just a general number. This is not a promise or a quote to any of you, but this is something that I like to prepare our clients for, that this is generally what it's going to end up costing you to get an attorney involved. This is a very simplified flow chart of what the court system looks like when it comes to unlawful detainers. This is after the 3-day notice to pay rent or to quit has been served and has already expired. At that point, we're going to file what's called an unlawful detainer. And it's because we're focused on them unlawfully detaining your rental property without that payment of rent. Once we file that unlawful detainer, there's pretty much 3 options that can happen here. Either the tenant moves out, the tenant does not file a response to that unlawful detainer, or the tenant does file a response. Of course, if we're able to continue negotiating with the tenant and after we've filed an unlawful detainer, the tenant moves out, at that point we would dismiss the unlawful detainer, and if we want to pursue a monetary judgment, that's a separate issue. Unlawful detainer is just about possession. Now, the second option, if the tenant does not file a response, in that case we can file what is called a default judgment. That allows things to move much quicker, and I'll show you on the next slide kind of the timeline for those different options. But if they don't file, we're able to just get a default judgment. We don't have to go to trial or anything. Of course, in the third option, if they do file a response, that response will include things that we might have to address. In addition, we would have to go to trial and then wait for a court decision. So this is just a quick overview, like I said, a very simplified summary of what the options are. Even once we file that unlawful detainer, it could go 3 different ways. Now, like I said, that timeline. So once we serve the unlawful detainer, there's a 17-day response window. Like I said, tenants can respond or they can choose not to, but we have to give them time to respond, and that's a court-mandated timeline. If the tenant responds, again, they could claim that it's uninhabitable, they could claim discrimination, they could claim a variety of different things, and we usually have to address or provide documentation that that's not an issue, and that happens fast because the trial date is usually set within 4 weeks. This is, of course, if they respond, and if there's no holdup in the court, then the trial does happen very quickly, but again, that trial can get pushed often. Tenants can file for a continuance or an extension for a variety of reasons, but if they respond, we have to be really quick with providing the documentation to refute any of their claims that they're making in terms of why they are withholding rent. Now, if the tenant does not respond, that's when we would file for that default judgment. And I say we, meaning our legal team, would file for that default judgment. Unfortunately, even if the tenant does not respond and we file for that default judgment, it can still take up to 16 weeks to receive a default judgment back from the court. And not much is happening during that time other than our case is in that court's caseload waiting for its turn to come up in front of a judge. This is where we as property managers would be reaching out to our clients and giving you the update of nothing has happened, but still trying to keep you in the loop that we are in this waiting game of filing a default judgment and then waiting for the court to agree that it's resolved now. We've won the unlawful detainer. However, after that happens, once we have that writ of possession, we are still then often waiting for a sheriff lockout. And that lockout has another timeline that starts. Waiting periods can be anywhere from 2 to 5 months in terms of waiting for the sheriff to actually get out to the property and do a lockout. All right, all of that said, having shown you the flow chart and talked about some of those timelines, the total expected eviction time, minimum 5 to 6 months, which I know is terrible news to hear. No one wants to talk about the ugly side of property management, but unfortunately, if you have to go the route of filing an unlawful detainer and waiting for the court to take care of things for you, minimum 5 to 6 months, oftentimes more than 7 months if there's hiccups or extensions or any sort of extenuating circumstances. It can take even longer than 7 months. And unfortunately, we've seen that happen with our clients. It's never fun for anyone, and it's something that we try to avoid if at all possible. So let's talk about the cost of an eviction versus eviction avoidance. Forgive the pun, but what makes the most sense? Because this is a financial decision. This shouldn't be an emotional decision. This should be something that you consider when it comes down to the cash flow of your rental property. So this was just a quick estimate that I gave for you based on a property renting at about $2,500. So the total cost of an eviction, counting in those attorney expenses and the cost of lost rent from, say, about 6 months of rent at $2,500, it's gonna come out to, at a minimum, $17,500 even. And that's a minimum, right? This is assuming 6 months. This is assuming reasonable attorney expenses. That's the cost that you're looking at. However, if we're able to be successful in avoiding an eviction via an eviction avoidance negotiation, then we're gonna have the cost of lost rent, and let's say that that's about 2 months, right? The first month where they didn't pay, we went through our standard delinquency process, and then maybe that next month of negotiating, of trying to get possession back, maybe there was some time there where we had to do some repairs to the property and get it re-rented. So we'll say 2 months of lost rent, and imagine you gave them their full security deposit back, right? These people moved in at $2,500, and you said, here's your full security deposit back in exchange for those keys. That's going to cost you $7,500. When you compare these two costs, that is still worth it. And that's what I mean by, does it make sense, right? Emotionally, we all want to decide that, no, I need to file an eviction. No, I need to go after them for this. But if you look at the dollars and cents of it, that is a $10,000 difference between going through a full eviction process using just the court system and no additional negotiation when you compare that to an eviction negotiation. I like to point this out because I often am the one having those conversations with our owners, and I get a lot of hang up on this portion right here, the payout of $2,500. And it seems impossible that an owner would want to spend $2,500 to get their tenant out of the property when they're not paying rent or maybe they've caused damage. But when I play this out for them and run the cost of an entire eviction process as opposed to getting back possession of your property within a month or 2 months or even 3 months, financially, it makes sense to avoid the eviction at all costs, right? Because that's what you're looking at a minimum when it comes to the cost of an eviction. In summary, I want to remind you all that this is how we handle things at Uplift Property Management. Every property manager does things a little differently, and lawyers might make different legal recommendations to you. So if you have specific questions about your property or about a delinquency that you're experiencing, call us today. We'd be happy to talk you through the process and give you guidance or advice regarding what the next steps for your property should be. We oftentimes take on new clients when they're dealing with these evictions or significantly delinquent tenants, and we've been more than happy to step in and help you out with your rental property.